Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica.
Fourth pretrial, tempers rising, and nobody's getting paid. The landlord says the tenants are stalling. The defense fires back with emergency repairs and a last-minute withdrawal. But the judge? He's already spotting the problem. You can't play both sides of the same argument. Watch closely, because what starts as a motion fight is quickly turning into a credibility test. And when the court starts asking why now, somebody's strategy is about to fall apart.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k Plan.
Donna Tope on behalf of Erica Ward and Aaron Ward tenants.
Your Honor, I believe my client, Griffin Hawk, I think I see him right now. He's on Zoom. He couldn't attend today.
All right. Yes, what is your name, sir?
Me? Griffin Hawk.
Yes, sir. Say again.
Griffin Hawk.
Yeah. Okay. All right.
Your Honor, we're here for our fourth pretrial hearing. If you recall from the last hearing, you adjourned to give plaintiffs time to seek alternative counsel.
Right.
It appears that they used that time to file a dispositive motion and an omnibus motion for repairs and Ms. Tope's motion for withdrawal 2 days before this hearing, which I received a copy at close of business on Wednesday, which forced landlord to file its own MSD, which was filed with the court this morning. So it appears it is further delay by tenants, and it's another month with my client not receiving any rent payment for his property.
So I can just tell you what I agree with everything that you've said. I can just say from the court's perspective, because of the way that my docket is, I did not see these various motions actually until late yesterday, but I have a life. So it was really this morning that I saw that, and then I saw your motion came in.
Yes.
And I have that.
Your Honor, I do also, I brought a hard copy if you needed one.
Of your motion?
Yes, landlord's MSD. You got it? Okay.
I got it.
Good.
Okay. So, Ms. Tope.
Yes. I filed judge's copies for you that had the tabs attached for the 3 motions for repairs, one of which is an emergency, and that's why things were delayed in getting the motions to you. I also filed a motion for my withdrawal, and I gave the underlying theory that the tenants have agreed with, and that is ready for your signing. I attached an order at the back of that. And then I filed, and it's effective midnight today because we had the emergency request for repairs that was made a week ago. And we filed a motion for dismissal with prejudice and damages based on retaliatory eviction.
See anything wrong with all of that?
Your Honor, I know you have expressed several times your not order and not opinion, but your advice that my representation of the wards somehow is ethically compromised. But I have tried each time that I have appeared before you and you have expressed your concerns, I have tried to give you the underlying basis for why I represent them and how I have conducted myself in that representation, including today. And that is in my motion, the underlying legal basis, and it's on Exhibit 1 at page 5, and it says that a bank account or other account held by a third party generally established in the name of the tenant into which whole or partial rent deposits are made to show that the tenant was ready, willing, and able to pay the rent, but is withholding the rent until a certain problem is fixed. And that is exactly what Erica Ward did. The money was not held in a legal IOLTA account.
Which might be part of the problem.
And you say might.
You can't do both.
Okay.
Counsel.
Okay. I agree. My clients and the plaintiff do not need to spend any more time with your concern with how the money was held. I have filed a withdrawal. They have agreed. They are perfectly able, competent, and know everything about this case and are wanting to exert their right to represent themselves. And that's what this motion says. So they signed it. It's a stipulation, and I've signed it, and I have the order ready for you.
So are they really? So if that's the case, then why is this effective at midnight?
Excuse me?
Why is it effective at midnight?
Because we had this emergency request, which we made to them. Why Erica, made to them to fix electrical fixtures in the residence that are used for auxiliary heating, which in this temperature weather is essential for the safety of the residents, and the outdoor security lights, which have gone out, and with the unsafe conditions out in the driveway and the walkways, those are essential. And the plaintiff refused to reply, refused to make the repairs. And so that, knowing that we had this hearing today, that is one of the motions, motion number 3, which is requesting permission for the defendants to make essential minor or electrical repair, which the plaintiff has refused to address, and to deduct the cost from the rent on January 1st.
You can't have it both ways.
How
You can't have it both ways.
There it is. The judge draws a hard line. You can't claim urgency while juggling conflicting positions. That's courtroom whiplash. When your legal theory starts sounding flexible depending on the moment, judges stop listening and start scrutinizing.
Then I would ask that you recognize that the wards made that request of the plaintiff, take me out of the picture, and they did not reply. And if you would like them to stand up here and say exactly what we say.
Are they going to be able, folks, are you going to be able to give me the legal arguments that are necessary?
Legal arguments? I
Yeah.
have to state the facts.
Okay, but you understand that I would be taking facts as I found them, applying a legal standard to that and making a decision. You understand that?
And are you prepared to make the legal arguments?
I guess I don't understand that.
I understand your question. I think we're in tough.
So what's the answer?
Yes, we are. We'll do the best we can. You know, we have a business that doesn't make any money. The attorney fees would be.
Sir, I get it, but I also can't.
It's a tough situation. I
Pardon?
understand your question. So yes, we'll do the best we can. And it is what it is.
Let me ask this. The conditions that are complained of, how long have those existed?
So,
The electrical outlets.
the electrical outlets on the outside I've only noticed as of this winter. They were working fine.
So how does this become an emergency motion?
Because the water freezes and then
No, I get that happens in cold weather. I understand
I
that.
have to use water heaters.
Okay, but I guess maybe I'll ask this. You're asking me to address this as an emergency motion where the court has only had an adequate opportunity to view it. Plaintiff has only had as short time, if any, to look at it.
The court isn't buying the emergency label. Timing matters, and filing days before a hearing raises eyebrows. Judges expect true emergencies to look, well, urgent. When the timeline feels manufactured, credibility starts slipping fast.
And I have to first determine that it's an emergency. And I'm having an issue with that. If you'd known the conditions existed, this motion shouldn't have been filed on Wednesday.
The reply was made. The request to repair the electrical was made when? A week ago.
Yeah,
But that's not the issue.
I didn't realize it wasn't working. I tell you this.
Okay. The weather makes it an emergency. The receptacles that just were noticed that aren't working are used for auxiliary heat in the residence. The security lights just stopped working. The plaintiff was requested to make the repairs and respond, and they did not.
Folks, are you going to be able to handle this from a legal standpoint?
Your Honor, will.
You realize, so hang on a second. You realize that plaintiff has filed a motion for summary disposition. That's going to need to be answered and then argued before this court. Have either of you ever argued a motion for or a motion for summary disposition?
Oh, yeah.
How are you intending on doing that then?
I just saw it on the way here, so I didn't even review it yet.
It's the last one.
Oh, and I know where it is.
Okay. I'm not worried. I was trying to be helpful.
let me just tell you, I will hear all of these motions at some point. There's not a doubt I'll do that. But I don't and can't justify that motion is an emergency motion that
Your call.
plaintiff hasn't had an opportunity to view and respond to. But then you're requesting that I take some action as against plaintiff. And I don't deem this to be an emergency. I think I won't go as far as plaintiff counsel that it's a delay, but it's just, it can't be an emergency at this point. Because this condition, to the extent it does, must have existed. And it didn't just get cold Tuesday.
No, it didn't. But the need for auxiliary heat became apparent with this frigid weather.
Because of the water.
Hmm?
Because of the freezing of the water.
No. Because the electrical outlet in the residence became known to be faulty a week and a half ago.
I don't have any way to check that.
I know.
Any way to.
Well, I
I'm
did
not
include
not having them respond to that. Counsel, at best, when you have motions such as this, even though these are summary proceedings, you have to give them the time under the court rule.
we requested the repair a week and a half ago, and I included those emails and their non-response in the motion. And if you can't act on it now, I totally understand your ruling because it wasn't timely, but it was as timely as it could be given the fact that we gave them 4 days to reply to making the repair themselves or telling the tenant to make the repair, and we got no reply. So that's why the motion was filed on Wednesday.
I don't care.
Okay.
File the motion whenever you want. I
Yeah.
just don't see a basis to hear. I don't see a reason to hear it on an emergency basis.
Got it. We had this hearing already scheduled, so I thought it would be in judicial efficiency to present it to you now rather than.
There is nothing about this that is leading to judicial efficiency.
Well, that is a motive. That is one of my motives. It's judicial efficiency. I know you don't agree, but.
Well, no, I just don't need your help.
Because I can do that on my own. Counsel,
She filed a dispositive motion 2 days before.
Sharp pushback from the bench. When a judge says, "I don't need your help," that's a warning shot. Counsel tried to frame this as efficiency. The court heard overreach. In this room, control belongs to the judge, not the loudest strategy.
And is now claiming that it's an emergency. Your Honor, I would add that if you're going to when you're addressing the pending motions, to rule on our motion first because it moots out their motions. And also when they're talking about emergency, my client is also being prejudiced because he's not getting any money from the property and he's defaulting on his own financial obligations. Mr. Hawk can provide more information on that, but he's suffering his prejudice while they're delaying for months. I mean, Your Honor, we're going on almost half a year where they're not paying rent. So, Your Honor, I would respectfully ask you to rule on our motion.
and let's just be clear in terms of the not paying the rent. I permitted plaintiff to keep a certain portion that he had been paid to him, whether rightfully or wrongfully it was deducted, but I permitted him to keep that. And I have in escrow the ordered amount of the $41.25, which I ordered in November, and December's $5,500 has been placed in escrow.
I should have been more clear. Receipt of money, Your Honor. I would.
No, I know what you meant, but I just wanted the record to be clear
Yes.
as to.
I would like to make a point though on the partial payment. My client's Chase bank account, because there was no activity with them not paying rent, it was, I think, deactivated, so he can't even cash this check. They're saying that he cashed the check. He can't cash that check.
Well, it was withdrawn. The check was cashed and the